We are here this afternoon for 3 separate oral arguments, and the first one is Betz versus Mathisen and others. Looks like the parties are ready. Ms. Hempy, you may begin.
Good afternoon. May it please the court, counsel. A party's right to have their day in court carries with it the obligation to be bound by the ruling reached by that court. In this case, plaintiff Linda Betz had her day in court in her first federal district court lawsuit. She was on notice of and actually litigated the defamation claims she has brought in the second lawsuit. How do we know that? Well, she told us. She pled in her first lawsuit that additional slanderous and libelous statements had been made about her ability to perform her job or the circumstances surrounding her termination. As the Court of Appeals dissent correctly found, these allegations are a killer to the claims she tries to bring in this lawsuit. I want to start out with the inquiry notice issue, which split the Court of Appeals, and our recent request for the court to take judicial notice. We've requested that the court take judicial notice of another document filed in the federal district court docket, specifically an affidavit of counsel. There's 2 rules that allow us to do that. Iowa Rule of Evidence 5.201. The court can take judicial notice at any time of any fact that can be accurately and readily determined from sources whose accuracy can't reasonably be questioned. That's exactly.
That particular document before the district court.
That's why we are requesting the court take judicial notice of it.
Oh, you're asking us to reverse the Court of Appeals based on information that was not before the Court of Appeals or the district court. Isn't that kind of a little bit unfair to those lower courts?
For the reasons stated in the district court, by the district court and the Court of Appeals dissent, this court does not need to necessarily rely on the document that we've requested you take judicial notice. It's simply, in anticipation of the question, well, Ms. Hempy, is there anything else in the federal district court docket indicating she's on inquiry notice? The answer to that question would be yes, and here's an additional document. But the district court found, the Court of Appeals dissent found, even months prior to this document, she was on inquiry notice in November 2020 by the allegations in her own pleading. If the court were to want to give Ms. Betz every benefit of the doubt and say, well, maybe her pleading doesn't mean what it says it means. That's what she's argued here, that no, that upon information and belief allegation refers to that Form 8K. We were really focused on that Form 8K. If the court really wants to accept that as true and disregard the language of her pleading, certainly by this affidavit of counsel in February 2021, she specifically referred to an internal complaint and investigation, and certainly is on inquiry notice at the latest by this date. Of course, we would also argue, if not much earlier, by the allegations in her own pleading. But this is a document that the court can properly take judicial notice of pursuant to the rules. For the same reasons we've previously briefed, that the court can take judicial notice of Ms. Betz's prior petition. So there's really nothing new here apart from the fact that we haven't previously raised this document. Looking at inquiry notice generally, the majority of the Court of Appeals found that what Ms. Betz knew and when she knew it was a fact question that should be decided by the district court. But the Court of Appeals majority didn't address what other facts were in dispute, right? If we remand this case, what is left for the district court to decide? We believe that the Court of Appeals dissent correctly found that there are no facts in dispute based on her own pleading and her prior allegation that she was on inquiry notice of these defamation claims. In fact, did intensive discovery on those defamation claims in her prior lawsuit. Those claims were dismissed on a motion to dismiss, and then those facts were in fact actually litigated at the motion for summary judgment stage.
You raised a point of this was on a motion to dismiss, and generally we look only to the pleadings when we're looking at a motion to dismiss. So given that, why should we look at the affidavit even if we did decide to take judicial notice of it?
That's a great question. So on a motion to dismiss, the court must accept as true the facts pled in the petition, in addition to any facts that can be appropriately judicially noticed. So here it is proper under a motion to dismiss standard for the court to consider facts which can be judicially noticed.
Any fact that can be, isn't that generally a fact related that's referenced in the complaint? So if you talk about a contract, you can go look at maybe what the terms of the contract are. But what authority lets us look at just anything that we could take judicial notice of when it's factual like this, as opposed to like a legal issue?
Yes, Your Honor, that's a great question. I believe the case law refers generally to any fact that is subject to judicial notice, particularly because those facts, to take judicial notice of a fact, its accuracy can't reasonably be questioned or in doubt. That's the exact situation we have here. We have
Judgment issue as opposed to a motion to dismiss issue.
It could be both, Your Honor. Here we filed in the alternative a motion for summary judgment. So under either standard, I would argue that this is an appropriate fact for the court to consider. Importantly, a party's placed on inquiry notice when they gain sufficient knowledge of the facts that would put them on notice of the existence of a problem or a potential problem. Again, if we look at that federal district court pleading, Ms. Betz has pled, upon information and belief, I know there's a problem here. I know there are additional slanderous and libelous statements that have been made about me surrounding my termination or my ability to perform my job. That's exactly the type of inquiry notice we have here. And under that 2-year statute of limitations, this court doesn't even need to reach the issue of whether a discovery rule applies, because even, again, giving her the benefit of the doubt, the court can assume without deciding, even if a discovery rule applied, her claims would be time barred under inquiry notice.
Didn't know the identity of the potential defamers or the tortfeasors.
Not the standard for inquiry notice, so it does not matter. Inquiry notice means she just needs to be on notice that there's a problem. If this court were to require that she needs to know, have the complaint in her hands, that would be an actual notice standard. The standard's inquiry notice, she just needs to know there's a problem and have a duty to investigate the cause of her injury or the facts giving rise to her injury.
Related, in a defamation case like this, how closely related do the different claims need to be? The original claim in federal court related to the K-8 filing, and this state, at least the argument seems to be that it's related more to an internal complaint. Are those sufficiently closely related when it comes to defamation, to kind of follow up on Justice McDonald's question?
That's a good question here, and there's really a lot of overlap between the inquiry notice arguments and the claim preclusion arguments. On the claim preclusion side, to answer your question, the claims need to be those that could have been brought. So again, even if we're to give plaintiff the benefit of the doubt that prior lawsuit was limited to a Form 8K, and these are different defamatory statements at issue, as long as they could have been brought in that prior lawsuit, she's precluded from bringing them now. We would argue that these statements were actually litigated, right? That they're not separate defamation claims. Because of that, upon information, it specifically states is not limited to, right? We have our pleadings about the Form 8K, and then upon information and belief, additional statements have been made. So clearly, these claims are the same claims, but again, even giving the benefit of the doubt, claim preclusion would preclude her from raising additional claims that could have been litigated.
Some of the defendants in the state court were not defendants in the federal court?
It does not, Your Honor. We have argued the defendants are in privity. Particularly, Mike Wilson is the same defendant, and it's conceded that he's the same. But as to Mathisen, Muller, and Rasmussen, they're clearly in privity.
You work when you're not trying to go through the employee to get to the entity. You're really kind of doing it seems like backwards. You're saying that the entity was in the federal lawsuit, and now so they are privity with the employee when the defamatory statement is allegedly made by the individual person.
Yes, Your Honor. I believe that point was raised in the resistance to the application for further review. If you look at the Petmeyer case under Iowa law, while that's applying, the reverse of what we have here, the court quotes from and relies on other authorities that state that privity flows both ways, from the agent to the entity and the entity to the agent.
Concern I have, Ms. Hempy, about this privity argument is, all right, so these individuals that are being sued, they allegedly defamed Ms. Betz, and so then they defame Ms. Betz by, and the damage that's done to Ms. Betz is the corporation fires her. So now you're saying, well, actually, they defamed Ms. Betz to the corporation, and the corporation and the individuals are one and the same. Isn't sort of the theory that Mr. Carroll's pursuing that they're separate from each other, the corporation or the home loan bank and these individuals are different? Otherwise, they can't you can't defame someone to yourself, right?
I think I understand your question, Your Honor, and I do
Then.
believe Ms. Betz has argued on appeal that the employees were acting outside the scope of their employment and that this is a vicarious liability standard for privity to apply, and if they're acting outside the scope, then that standard doesn't apply. That's what I understand her argument to be. I would point out that argument is contrary to what she's pled in her lawsuit. She has pled in her lawsuit that Mathisen, Muller, and Rasmuson were at all times material employees of the bank, and her pleadings, the factual allegations relate to, Mathison's making a complaint about the internal SOX control, the auditors are investigating that complaint, Wilson is making these statements to the board as part of the findings of the investigation, right? These are all the types of statements that are being made in the course and scope of employment just based off of the allegations in her petition. So just solely even just accepting as true what she's pled, I believe she's pled herself out of court and they're in privity with the bank. I don't know if that answers your question.
What should she have done? The Court of Appeals here says that these statements were inherently secretive in nature. After she filed her federal petition, what then?
She should have amended her complaint and added these parties. She had opportunity to do so and brought, to the extent that she didn't bring these claims already, which again, it is our petition that she actually brought these claims in her first lawsuit. To the extent that she didn't, she should have. She had opportunity to do so. The parties agree at the very latest, she had this complaint and investigation in her hands and discovery in that case in April of 2021, well in advance of the deadline to amend her claim and litigate these claims. I would point the court to the Pavone case, very similar facts as alleged here. The party in the first lawsuit learns of facts that give rise to their cause of action that they try to litigate in the second lawsuit. But they wait, they hold those claims back until they lose the first lawsuit, and then they file them after the first lawsuit's been dismissed. The court in that case said that they should have litigated them in the first lawsuit. That's claim preclusion. That's exactly what we have here.
Could I ask you about one more question about your motion for judicial notice? We had a case last year, Petterzellic, if I'm saying that right, and they had a very similar motion to expand the appendix based on some judicial notice materials and from other litigation that was related, and we denied that. I don't know if you were aware of that case and if you had any thoughts on.
Your Honor, I can distinguish it in saying that in that case, the court specifically found that there were other exceptions that didn't apply. So the court cited to Iowa Rule of Appellate Procedure 6.804, I believe, and specifically said that subsections D and E did not apply. Subsection D is what we are proceeding under, that documents in a related case can be part of the appellate record if they are proper subjects of judicial notice. So I think that case just doesn't apply to the rule that we're invoking here.
You began your argument with the inquiry notice issue. Whether or not there should be inquiry notice or a discovery rule on defamation, are you conceding that we should have some sort of discovery rule?
We are not conceding that. We're just simply stating that the court need not reach it. Certainly, if the court wants to reach that issue, we would argue that the court should not apply a discovery rule. Now, I understand this court has applied a discovery rule in a number of other cases, but it's never done so to defamation torts involving injuries to reputation. We would argue that they are a different nature than the type of cases that this court has previously applied a discovery rule to. In particular, defamation carries the concept of republication, right? It's already a very plaintiff-friendly rule, provides protection where every repetition of a defamatory statement is a new cause of action, a new running of a statute of limitations. Considering there are other protections like that in defamation law, when you're weighing the balance of interests of the discovery rule versus a statute of limitation, we would argue that the statute of limitations should run out, or should win that balance. I see my time is about to expire, and I'll be back up here, so thank you.
Good afternoon. May I proceed, Your Honor? May it please the court and counsel. Mike Carroll from Kearney Appleby in Des Moines on behalf of Resistor Linda Betz. Your Honors, the Court of Appeals was correct in 3 critical points in its ruling below. First, adopting the discovery rule for defamation claims that arise out of inherently confidential communications. Second, holding that Betz was not on inquiry notice of a confidential and internal complaint that she had no way of discovering. And third, properly recognizing that what Betz knew and when she knew it was not properly to be decided at this stage, and that that inquiry should occur in the district court. What I'd like to do is start with, I think, Justice McDermott, your question that gets to, I think, one of the issues that I think was a natural question to be asked, which is, well, why not just amend the pleading in the federal court? Why not do that? And so what I'd like to do is address that first. That case was filed in January of 2021 in state court. It was removed to federal court because it was the Federal Home Loan Bank that was the party. Immediately upon removal, then we had a motion to dismiss filed, and that was filed in approximately February of 2021. What happened thereafter in federal court, as most of you know, is we have a schedule that's established, and the schedule is a pretty rigid schedule in federal court. And we had a deadline set for first initial disclosures, and then second, we had amending pleadings. The amending pleadings deadline was set for July of 2021, July 1st of 2021. The motion to dismiss that the court heard in the federal court was pending until after the motion to amend pleadings, the amending pleadings deadline ran on July 1st. I think the federal court, trial court, issued its ruling on the motion to dismiss on or about July 21st of 2021. And so while we learned of the fact of the internal complaint relatively soon at the beginning of the discovery process, that was not everything that was bearing and important.
Filing a second lawsuit like the one you did file, how about filing that earlier? You would have been well within the 2-year time period for that.
Do you mean just filing in state court or federal court or either one?
Court, because you didn't have a federal cause of action, but yes, state court, filing a second lawsuit along the lines of what you filed here.
We were at that point making decisions about what we had to pursue and when we had to pursue it and what was the best place to pursue it. As the master of our complaint, we decided that the best thing to do was to ride the federal claim through until it was concluded, one way or the other, and then decide whether to file in federal court or state court at that point. So our main concern at that point was in federal court, the deadlines are rigid. The courts tend to hold you tightly to the deadlines, and our concern at that time was that if we filed a motion to amend the pleadings and the court denied it, that would have been res judicata. So we believed that we were probably going to end up in state court at some point, Justice Mansfield. The question was when we needed to file it.
If you were on inquiry notice from the time when you alleged in your first petition that there had been additional slanderous and libelous statements regarding plaintiff's ability to perform her job, if that was the beginning of inquiry notice, you had time within 2 years of that to file a lawsuit another lawsuit in state court. Isn't that right?
But I would say that we were not on inquiry notice at that time, and the information that we had available to us at that time indicated nothing about what we ultimately filed the second lawsuit about. The first defamation claim was only about the Form 8K and the defamation by implication, essentially, Your Honor. And we believed that there were probably other statements related to and that led to the Form 8K being filed. And ultimately, then the federal court dismissed that claim for several reasons and found that it wasn't good to survive a motion to dismiss in federal court. So that's why we did that.
About the record in this case and what we can consider, as I read what happened in front of Judge Smith, the defendants did file some materials from the federal court case, and you objected to them being considered for the truth of the matter, but you didn't object to them being considered as far as events that had actually happened in the federal court case. Isn't that correct?
True. I do think that's true. I mean, this case was unique. I'd say it's kind of a unicorn as it relates to the kinds of record that you're initially seeing in a motion to dismiss in state court. Usually there's no record at all other than the lawsuit. Because we had litigated, this case on several issues, there was a significant record in the federal court. And so there was no denying that some of that had happened. All of that record had been developed, but we did not believe it was dispositive of the claim that we were now bringing in state court, which was on the internal complaint itself and what that led to.
Bigger question, kind of threshold question, why should we even recognize a discovery rule on defamation claims?
There are several reasons that I think that we should adhere to a discovery rule in this case. And the main reason, Your Honor, is what I would call the not rewarding or creating a public policy that rewards the careful defamer. We should not observe a doctrine that says it is okay to defame as long as you keep it secret long enough for the statute of limitations to run. That would.
So I'm really having a hard time getting beyond the part that was summarized in the dissent. Upon information, which means you've seen something, and belief, which means it has been found to be somewhat persuasive to the petitioner or plaintiff, defendants have also made additional slanderous and libelous statements regarding plaintiff's ability to perform her job, which include but not limited to statements about the bank's regulator. Seems to me like that's sure smoke that would lead to fire. How can we pretend like if that statement had never been in there, I think you got something maybe, but how can that not be inquiry notice?
Yeah, literally had no idea. And I don't think that the bank.
Just read you the idea.
We had no idea that Ms. Mathisen had made an internal complaint through their private hotline that stayed confidential all the way through an internal investigation process. Had no idea through the time that my client was employed until January of 2020 or thereabouts. I'm sorry.
You're saying the federal case was against the bank and the state case was against individual employees. I understand that distinction, but I'm just having a hard time getting beyond that we had no idea.
She had no idea about the fact of the complaint. She had no idea until the complaint was provided to her in discovery. No idea about the fact of the complaint. And it wasn't until the complaint was provided to her that she was aware that a subordinate, a former subordinate, had made an internal complaint for all the reasons that we.
Aware that there was something that came up in her prior employer that served as grounds for her termination. And as you allege in the petition, defamatory statements. That's what was in the prior case.
When they were in a complaint, but she certainly, according to her own statements in the petition, knew about slanderous and libelous statements. Now, maybe she didn't know they came out of a complaint or whatever, but she certainly has said magic words.
Well, something that led to the Form 8K being filed, which she believed defamed her by implication because it did not say that she was fired without cause. She had no idea that an internal complaint had been made. There's nothing.
I agree. She didn't say by internal complaint. She's saying slanderous and libelous statements. And with notice pleading in Iowa, that's enough to whether it's federal. Did you say this started off in state, the federal one, and then got bounced back?
Started in state court, and it was removed to federal court. And that's where it was resolved.
This question, if you have a discovery rule for, as you call it, secret defamation or confidential files, if it doesn't actually cause any injury or a significant enough injury to a plaintiff that they don't even become aware of it, is that the kind of case that we should be concerned about keeping alive with a discovery rule? Does that question make sense?
I think it does. I think I would just flip it and say, here's the problem. You know, there's lots of defamation that probably happens that nobody ever finds out about. And of course, we shouldn't be worried about those things. But what happened here is we have a straight line from the defamatory statement through to, at some point, a termination. And so that's why, if we don't have the discovery rule in this case, she does not have a case.
Something bad did happen to her, and she was aware of it, and she filed a lawsuit in response to it. And it seems like having a discovery rule opens up this Pandora's box of potentially defamatory matter that's not really material in any sense. And then somebody says, well, I wasn't aware of it. And why would they be? Because it's not material to their life. It's not material to their reputation. Here it was material, and she filed a lawsuit about it. It seems like the rule works kind of perfectly.
She didn't file a lawsuit about it until within 2 years of when she found out about it. She did file a lawsuit about her termination, Your Honor.
We're discussing that about what she alleged or what she knew. I mean, the petition certainly says, it doesn't say defamation related to the 8K. It opens it up and says other defamatory matters, right?
We believed that they were all related to the 8K. We did not know what was there. That is a fact. Now, maybe it was inartful pleading on our part, saying that we believe there were other statements. We believe there were other statements that led to the filing of the Form 8K. That's what we believed it was about. She had no idea that somebody had made an internal complaint that accused her of certifying SOX controls as effective that were not effective.
She had a defamation claim, correct? And she alleged that defamation caused her unjust termination, right? In the original federal case.
She alleged that the defamation was a result of the filing of the Form 8K. Whether that defamation led to her termination is a different question. I don't know that we connected those two. We did believe it was certainly a cause of.
It says, so upon information and belief, defendants have also made additional slanderous and libelous statements regarding plaintiff's ability to perform her job or surrounding the circumstances of her termination. Doesn't that answer the question Justice Mansfield asked?
I believe that the general basis for the lawsuit, what was the initial cause of it was what my client believed to be discrimination.
Through in this paragraph, defendant also made additional slanderous. I mean, so I agree that that's where you were hitching your pony, but you threw in this as well.
Well, we did because of the Form 8K, and my client was exercised about the Form 8K that was filed in a public filing with the SEC that she believed put her in a false light, leaving the public with the impression that she was fired for cause, instead of the other people that were let go, and the forms that were filed with the SEC said that they were fired without cause or separated without cause, and that was the basis for it. You know, if we had known about the fact of the complaint at the time we filed the initial pleading, we certainly would have included it, absolutely. But that's not what we were talking about at the time because we did not know about it.
So what do we need to decide the inquiry notice issue? What would that trial or hearing look like?
Well, I believe if the court were going to make that determination, it would be to ask the plaintiff, what did she know and when did she know it? Right now, what we're doing is guessing based on the record before us. I'm telling the court that she did not know about it, but of course, at some point, she the court may want a more formal statement under oath about that.
You know, I think it was, Ms. Hempy was saying you don't need actual notice, you need inquiry notice. And the best indication that you had inquiry notice in January 2021 is it appears that pretty soon thereafter you did have, your client did have actual notice, and well within the 2-year limitation if we apply a discovery rule. And it was your decision, I think as you put it, to kind of ride the federal case to the end. But one consequence of that may have been you're too late now to bring a second lawsuit, right?
Well, that's right. I mean, that's the argument, but we believed that because we were the masters of our complaint, we could file it in state court. Now, I suppose we could quibble with whether or not we filed it in a timely manner. That's what this case is about. We believed we filed it within 2 years, and we believed we had the right to do so, that it was not related. Your Honors, I see that my time is up. If the panel has no more questions, I'll ask the Court of Appeals be affirmed. Thank you.
I want to start out with a point made by opposing counsel that they decided to ride the federal claim out, and that if they had amended their complaint to include these claims that they are now bringing, that they believe that would be res judicata as to those claims. That is the exact reason why they are still res judicata to those claims in this case. A party cannot deliberately hold back claims, wait until they lose their first lawsuit, and bring them in a second lawsuit. The doctrine of claim preclusion includes any claims that could have been brought. So that squarely applies res judicata in this case. On to the point of applying a discovery rule, I think the facts of this case show at least that this is not the case to apply a discovery rule. The discovery rule is applied on concepts of equity and fairness, that a party who has absolutely no knowledge of their claim, their injury, shouldn't be burdened by the statute of limitations. But here, it seems clear that Ms. Betz knew of her claim and, again, deliberately chose not to pursue it. And so, in fact, it would be inequitable to apply a discovery rule under these facts to the bank and its employees and force them to defend a second lawsuit. Fine.
Can I ask you a question about that? I'm struggling a little bit with our statutory interpretation in terms of when we apply discovery rules and when we don't, because so we usually talk about accrued, because that's the term in the statute, right? That the statute of limitations. And in a car accident case, for example, that we use a discovery rule, and that's a situation where we know, where often people know they've been harmed immediately, and yet there's a discovery rule that's applied in those circumstances. And I'm just trying to distinguish sort of what our operating basis for deciding what kinds of claims should apply the discovery rule and what shouldn't.
I believe this court has previously applied it based on that accrual language, that the cause of action generally accrues when the person knows or reasonably should know that there's a problem here, right? In a car accident, I mean, I think it depends on the facts of a case, right? You have products liability cases, for example, where the courts applied a discovery rule when a party can't know maybe who a manufacturer of a component part in a car is that potentially contributed to the accident. Again, I don't think that those facts are at play here based off of what Chief Justice Christensen has pointed out, that clearly there was smoke, right? She knew something was up, that defamatory statements were being made, and she's told us she was on inquiry notice of those claims. So I just don't know that, again, that this is the case to apply a discovery rule to defamation where it's clear that she chose not to pursue these claims. And then finally, I believe that Mr. Carroll's argument really is one that requires actual notice and not inquiry notice. And because the law in Iowa is inquiry notice, I think this court needs to affirm the ruling of the district court. If there are no further questions, we would ask that you affirm the ruling of the district court and vacate the ruling of the Court of Appeals. Thank you.
Parties, The case of Betz versus Mathisen and others is hereby submitted. We'll have a brief pause while the parties prepare for the case of Thorington versus Scott County.